The following is an example of how trials and cases go within The Hague. In 2003, the UN Special Court for Sierra Leone, or the SCSL, indicted the president of Liberia, Charles Taylor, for supporting rebels in Nigeria who caused many atrocities. The president, however, escaped into exile in Nigeria after an arrest warrant was placed on him. Early 2006, Nigeria asked for a trial against Mr. Taylor to occur in The Hague. On April 3, 2006, Charles Taylor stood in front of the SCSL and pleaded not guilty. And then a year later, in The Hague on June 4, 2007, the trial began with the prosecution's opening statement. However, Taylor refused to show up since The Hague had given his defense lawyers insufficient time to prepare for the case. Now, why would they do that? Starting in January 7, 2008, the trial picked up again as the prosecution started calling up witnesses. This process continued until February 27, 2009. During this time, Taylor's lawyers appeared in court. On April 7, 2009, Taylor's lawyers entered a statement of no case to answer or motion for judgment of acquittal. This means that the prosecution had failed to prove Charles Taylor's guilt. However, on May 4, 2009, the trial chamber had rejected these claims that the defense had made. Getting a little defensive after a claim that practically all defense attorneys say. Wonder why? On July 13, 2009, the defense opened with a statement from Taylor's lawyer, Curtin Griffiths, who said that his client is not guilty of the charges against him. He also raised some interesting points about The Hague itself and this trial. The lawyers asked the question, why isn't Gaddafi also on trial? Gaddafi happens to be the leader of Libya. Also, Griffiths said, and has been quoted for saying that The Hague would have been refused funding by the British government if The Hague had arrested Gaddafi, because a man by the name of Tony Blair and the British government were anxious to pursue economic interest in the Libyan country. The defense then went on to say that the entire trial was a politically motivated conspiracy. Griffiths said that this trial was besmirched by the lofty ideas of international criminal law to turn this case into a 21st century form of colonialism. Also, on July 13, 2009, Charles Taylor took to the stands. He then denied having any knowledge of the rebels. During this time, the release of the diplomatic cables by WikiLeaks was let loose, and this just shows how the trial was not only unprofessional, but was intended to be so. On August 5th, supermodel Naomi Campbell testified against Taylor, and the defense claimed that this was just another attack on Charles Taylor by using a celebrity to bring attention to the trial to gain support against him. On March 11, 2011, the trial finally came to a close after 3.5 years. Judges are expected to come out with a decision in September. But should they be allowed to? Obviously, this trial has had its ups and downs, and makes one really wonder what the ICC is up to, and if they are committing actions in order to benefit themselves. And if so, is that really justice?